Thank you, Deputy Speaker. So the government moved this bill on the 21st of November 2024, just last week, and it is the third of a suite of bills with which the government appears to be on a very rapid race to the bottom in its attempts to mimic the draconian efforts by the last government to treat the most vulnerable people seeking asylum in this country, in a fashion which is not humanitarian, is not generous, and does not recognise or reflect the values of electorates like the one that I represent. I want to note for those constituents of Koong who are watching tonight that this is not a new bill. This is the fourth time that this bill or an iteration of it has been brought to the House. The first time was in 2017 when Peter Dutton was the Immigration Minister. The bill was reintroduced in 2019 and 2020, and on each occasion it failed to pass because there was a significant backlash both from other sides of the House but also from the community. And in fact, when the ALP wrote a dissenting report to this very bill, essentially in 2020, it noted the extent of community backlash and revulsion, really, about the premises of the bill. That actually led to a community petition which was signed by 140,000 people. 140,000 Australians expressed their disgust at the measures that we're discussing with this bill. They had the opportunity to do that because this is a democracy, and in a democracy people have a right or an ability to feed back about things that the government is planning and that they care about. But citizens are denied that right when a bill is put before the House with this degree of haste. So what would this bill do? This bill would essentially give the minister sweeping powers to ban almost any item in a detention centre. Those items would include everyday items like mobile phones. And so the bill has the ability to cut people who are vulnerable and already in a place that they do not want to be, subjected to conditions in their life that they do not want to live within. It would cut them off from their loved ones and would cut them off from their crucial supports. It would limit their ability to hold the government responsible for the circumstances of their detention. Under this bill, as it's laid out, the minister can determine that almost any item is a prohibited item. Now, that could be things which are illegal, which could be the subject of criminal activity, but they could also be things that the minister believes might be a risk to the health, the safety or the security of people in the detention facility or to the order of the facility, whatever that might be. The bill also expands the basis for officers in the detention centre to undertake invasive strip searches. It gives broad new powers for officers to conduct area searches within the centre, which could include examination of people's rooms, their personal effects, common areas or even medical examination areas. And officers within the detention centres will be able to use force to conduct those searches. They can bring dogs or other external people in to help them. They can confiscate items that they believe have been banned. It doesn't matter whether or not the person has been shown to have actually misused their phone in the past or have engaged in any conduct which has put other people at risk. If the officer feels that this is a reasonable thing to do to reduce any risk to health, to safety or security or order in the detention facility, then the officer can do that. And we can imagine how that power might be misused by people who don't necessarily have inmates' detention, inmates' conditions in their best interest. The bill also gives the minister the ability to issue blanket directions about the exercise of search and seizure powers within detention centres. Now, it's important, I think, to note that many of these powers are actually already in the hands of the minister and of people who run these centres. They already have search and seizure powers if they are dealing with illegal or dangerous items in a detention centre. We have to remember detention centres aren't prisons. But the distinction that appears to be moot in the context of this legislation. The Minister and officers are already able to undertake those searches and those seizures under the Migration Act, under their common law duty of care. And it is, we have to remember as well, remembering that these are not prisons, that these centres are in some instances, many instances, being staffed by contract personnel who are not subject to the same rules or degree of oversight, shall we say, as police people or ABF. I think it's really important that we note that people who are in detention shouldn't have to exist under a harsher regime just because of their visa status. These people are not criminals. Now, some of them, we're told, have been guilty of criminal activity within the detention centres that we're discussing. But if that's the case, then the people who are running those centres have the ability to resort to the criminal justice system. And the mere fact that that sort of activity might be taking place is not a justification for changing the rules around the place themselves. Were that the case, then you could argue that the similar powers should be given to teachers in schools, where very often illegal activity is undertaken, or at music festivals or any other spot where people undertake illegal activity in the conduct of their activities. I think, at the end of the day, we have a duty to first do no harm to people who are vulnerable in our justice system, whether that be the criminal justice system or the immigration system. And I think it's worth us remembering that between 2019 and 2024, there were more than 700 episodes of self-harm by people in immigration detention centres in this country. There were 29 deaths. And it's hard to imagine the imposition of the rules that the government has put before us with such lack of due diligence or consultation or an ability for community feedback. They will hurt people. They will hurt people who are vulnerable and who are already, just by the circumstances that lead to them finding themselves in these immigration detention centres, lack the power and the agency that ordinary Australians have. It's also worth remembering that this particular bill that has been put in front of the House with such short notice is only one of 3 significant bills that the government is pushing through with unseemly haste at this point in time. We've recently seen the Migration Amendment Bill, which has imposed ankle bracelet and curfews on prisoners. We've seen our government which is arranging to pay other sovereign states to take our non-citizens, but we don't have a whole lot of clarity about what that involves. And we've seen the government reviving its deportation bill as well. This is not the sort of Labor government that many of us expected when Mr Albanese became Prime Minister in 2022. I think many Australians expected a government which would be more just and more generous. Gandhi said that a true measure of any society can be found in how it treats its most vulnerable members. This treatment is not reflective of the Australia that I know and that I love and that I hope to represent.
The question is that